Hi everybody, it's Jack Meligan from the Plaintiff's MSA and Lien Solution here with you again. Today, I thought I would record hopefully what I think will be a short video that the goal is to replicate our initial consult phone call. So if you don't have a case right now, or if you're watching this late at night or early morning and you're wondering whether or not you've got a Medicare issue regarding future Medicare expenses in your client's potential case settlement, then this video will give you a general overview of what we would cover in a telephone consult, an initial consult on your client's case, and it'll cover some of the same questions and some of the same answers that we cover in that initial consult without you having to call us. So here we go. First off, we always like to start off our consult calls with a revisit to the law as it currently stands. And the law currently does not require an MSA. Not in a liability case, not in a workers' comp case. It's not ever been there, going all the way back to 1965 when the Medicare statutes were brought into our laws. Now, no law requiring an MSA, but since 1980, the law has been very distinct and says that Medicare is secondary to workers' comp, all forms of liability insurance, self-insurance, and no-fault insurance. And that means that if your client has a settlement, Medicare assumes that some of the settlement is for future medical, and therefore they expect your client to pay some of their future Medicare allowable bills related to the injuries or conditions that are the subject of the settlement that you are obtaining for your client. Medicare expects your client to pay some of those bills out of the settlement, unless they've got a good reason why they're not, and I'll talk about that too. So since 1980, that law has been on the books. Now, since 2007, there's another law that affects plaintiffs and the potential for a liability MSA, and that law is what we call the Section 111 report law. In 2007, the law was changed to force the defendants and their insurance companies, referred to as responsible reporting entities or RREs, to make a report every time they have a settlement with a plaintiff who is Medicare eligible. The definition of Medicare eligible is they have their Medicare card in hand. So your client settles their case, they have their Medicare card in hand, the defendants are required to report that settlement to Medicare, CMS. Now, what are they reporting? Well, these reports have contained as many as 196 data points at various times, but there are three, no matter what permutation it's in and how many data points there are three that are critical to plaintiffs. The date of the settlement, because that's a dividing line between past medical and future medical. The total amount of the settlement, also known as the total payment obligation to claimant, or TPOC, and then the ICD-9 and ICD-10 codes, the international disease codes, that identify the injuries and conditions that are being settled in your client's case. These all go into Medicare. They are supposed to then be transmitted into your client's common working file, and they remain there until bills start coming in from the doctors that are treating your client. And if Medicare is able to match up the ICD codes in the bills that are coming in with those ICD codes that were reported at the time of their settlement, it's supposed to generate a denial of payment letter, which means the bill goes back to your client's doctor, the doctor then sends it to your client, and then your client pays it, or decides to maybe call you and say, hey, what am I doing with this, because I'm out of money. So that is why an MSA may actually be a good idea for some of your clients. Which ones? Well, the ones that you're worried won't be able to hang on to or have the money available to pay those future Medicare bills when they come due, sometime down the road, maybe way into the future, but when they come due, Medicare is supposed to be watching, and if you're worried that your client won't have the money in a safe spot and still have it so that they can pay those bills, then that is the type of client that may benefit from having an MSA account. Now, any discussion about your client's situation when you call us is going to start with avoidance. And I've published on this. We've got a 4-page digital handout on avoidance. We call it the 3 ways to avoid an MSA. And I'll add on to that, there's 3 ways to avoid an MSA without jeopardizing future Medicare eligibility and without creating long-tail liability for you, the trial attorney. So the 3 ways are: 1, if your client's been released from treatment by the treating physicians in their case, and they can get a letter from the doctor stating so in writing that they've been released, that's their golden ticket out of this whole MSA Medicare issue. If they can't get that, then you can submit their case to us. Let's say the doctor has released them, but the doctor won't send you the certifying letter. Then you can bring that case to us, and we'll craft an MSA allocation study. If it turns out they've been released from treatment, it's going to generate a 0 MSA, and now you've got another piece of documentation in your client's file that they have addressed this situation. And then the 3rd way to handle this is it may be possible to obtain a legal opinion from one of the top Medicare lawyers in the country as to your client not having any liability for future Medicare bills due to the circumstances of the settlement, or that their liability may be greatly reduced from what an MSA allocation would identify as a potential amount. So those are the 3 ways to avoid. That's the way we start our discussions. And then once we've got you in that position where you understand the law as it currently stands and whether or not your client can avoid, then you and your client can make some decisions about how to move forward. And as part of that, we will send you, upon request, our disclosure document that you can use with your client. And the disclosure document covers all these issues and gets their signature below the boxes that they can check off that they use to tell you what they want you to do about this problem for them. But it's a great way to save you time and get your client's wishes and authority down in writing on a piece of paper that'll stay in your file forever and ever. After that, we've got a menu of services depending on what your client needs or wants. We can do MSA allocation study from the medical aspect. We can help you line up one of the top Medicare lawyers in the country for a legal opinion, which may greatly reduce or even eliminate your client's liability. And then finally, if your client does have an amount of money that they need to set aside in an account and protect for future Medicare bills, and they don't want the hassle of trying to manage that and administer it themselves, we have a professional administration service that is second to none. So that's our initial consult. If you have more questions about a specific case or specific issues or facts and circumstances in one of your cases, give us a call. The number is right below. This has been Jack Meligan for the Plaintiff's MSA and Lien Solution. Back to you again soon.